Mark's mics.
Oh, okay. All right, whenever you're ready, Joe. Okay, I'm going to call the meeting to order. It is, 7 o'clock, and it's October 28th, 2025. We're at the Genoa Township Hall, 5111 South Old 3C Highway, Westerville, Ohio, 43082. We have one case on the agenda tonight, BZA case 2025-10, which is an area variance for property located at 5760 Miss Flower Lane, and this is the first meeting for this application. Staff present is Paul Benson and Joe Schaefer, and I will call the roll. Ms. Yu?
Here.
Mr. Phillips?
Here.
Mr. Wilcoxon?
Here.
Mr. Campanella?
Here.
Ms. Guest? And Mr. Holleran. Okay, see, I saw you this time, even though you're sitting behind Paul. Yeah, I know how you are. There you go. Okay, I'm going to read this into the record just as a matter of business here. As is the adopted policy of the Board of Zoning Appeals, all applicants will be granted an opportunity to make their formal presentation. The audience will then be granted an opportunity to comment, followed by questions from the board. This policy has been adopted by the Board of Zoning Appeals to provide for the orderly discussion of business scheduled for consideration. The chairperson may limit repetitive debate. Okay, first item that we need to take care of is review and approval of the Genoa Township, Genoa Township Development Zoning Department meeting minutes from August 26, 2025. I'll give you a moment to look those over, and then I will entertain a motion to approve whenever you're ready.
Okay, I didn't think so. Like, yeah.
Okay.
Yeah, they are here.
Yeah, I get your emails. Sometimes I reply, sometimes I don't. But I do read them.
Move to approve the minutes as prepared.
Okay, Mr. Phillips has made a motion, and I'll entertain a second.
Second.
Mr. Campanella. Okay, any revisions, any comments, anything? Okay, any discussion? All those in favor state aye. Any opposed? Hearing none opposed. Any abstentions? No abstentions. Okay, minutes are approved, and we will move on to our one and only public hearing at 7:03, which is an area variance. Those of you that wish to appear and testify in this matter, please stand and raise your right hand. There you go. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God? Yep. Thank you. Be seated. Okay. At this time, I will read the legal notice into the record. And David and Kathleen Sarver requesting approval of a variance to allow a principal building to encroach into a rear setback at 5760 Mist Flower Lane, Westerville, Ohio, 43082, which is currently zoned Planned Residential District, PRD. This is BZA case 2025-10. The legal notice for this hearing was printed and published on October 18th, 2025 in the Delaware Gazette and posted at the Genoa Township Hall on October 14th, 2025. An attempt to mail notice of this hearing to property owners contiguous to and across the street from the subject property was also made. We're accepting in as exhibits A through D, which is the legal notice, the sign-in sheet, application, and staff report dated October 21st, 2025. Paul Benson on behalf of Genoa Township, if you'd like to give us staff's comments, please.
Thank you, Mark. Just a quick little history of the property. The lot was created when Medallion Estates was platted in January of 1993. There was a house that was permitted in May of 1994. A deck was approved in March of 1995, and roof-mounted solar panels were approved for the property on April 12th of 2018. The staff received an application for this proposed addition August 26th of 2025. While reviewing the application, staff noted that the proposed addition was 22 feet from the rear property line. The Medallion Estates final development plan states that the rear setback is a minimum of 30 feet. So staff emailed the property owner August 29th, 2025, let them know that the proposal would be denied as is. Gave them the opportunity to say you could either request a variance, you could withdraw, you could amend it and to change the plan so that it would be within, not encroach into the 30-foot setback. The property owner, the applicant, did then contact staff. We did have a meeting with them September 4th, 2025, to discuss the plan, what the issue was. They determined that they, at that point, wanted to apply for the variance. So we did receive the variance request. We did send the application out to police, fire, and maintenance. Fire Marshal Cato did reply. He responded they had no concerns. And that is all that I have. Back to you unless you have any questions for me.
Okay, do we have any questions for Mr. Benson?
Not right now.
No? Okay. Well, then let's hear from the applicant. If you'd introduce yourselves, I'd appreciate it also.
I'm sorry?
I said, if you would introduce yourselves.
Yes, yes. I am Dave Sarver.
Okay.
This is my wife Kathleen Sarver.
Okay.
We are the owners of the property, and we are the applicants here. To my left is Joseph Yoder. He is
Okay.
our contractor, and his company is Diamond in the Rough.
Contractor. Okay. Go ahead.
All right. Well, first, we appreciate you hearing our request to have a variance here on our property. Currently, the area that we're talking about is at the rear of our property off of our kitchen, and it's currently a patio. We very much enjoy using that space, but we would like to use it even more than we do, and we would like to add a sunroom onto that. And as has been laid out here, the sunroom that we have proposed would result in a 22-foot setback rather than a 30-foot setback. We are hoping that you will find it reasonable to offer us a variance on that, because the distance from the room that we propose to add to the neighbor's house on the rear of our property will be about 137 feet. The property behind us has been fully developed, and the house that is on it has been finalized, and so we feel that you know we're not encroaching on our neighbors by having a 8-foot variance for our property here. Part of the reason that we are proposing the sunroom as we have it is due to the elevation of the roof line on our house, and the roof line that goes over our kitchen is about 1.5 to 2 feet lower than the rest of our back of our house. So it makes the most sense to go straight off and stick within that roof line for the addition that we are adding to the house. So
As opposed to going off to the side where it indents in.
Correct.
Okay.
Yes, correct.
Yes. The other thing that we think is significant in our application here is the fact that we have met with all 4 of our neighbors, the 2 neighbors on either side of us, the neighbor in front of us, and the neighbors behind us. We have showed them the plans that we have for our addition. We've shown them the impact of what we're hoping to do, and all 4 of them provided us with letters indicated they have seen those plans, they've reviewed them, and they have no objection to what we're asking.
I'm looking at an aerial photograph of your property,
Correct.
and it looks like it's a significant amount of trees directly behind you. Is that true?
We have 3 trees in
Well,
our
there are
backyard.
3 trees in our
Trees
back.
behind you, yeah. I'm just looking at the canopy. It looks like that there's a decent amount of shade to the property behind you anyway.
Yes,
Yeah.
there's a decent amount of shade to our backyard because there are 3 large locust trees
Yeah.
there, yes.
But the reason I ask is because it has an impact on line of sight and things like that. And it looks like it'll be pretty well blocked by the trees, at least in that direction to the south.
Anybody, any other questions? Wow, you're awfully quiet tonight. Should bring you in here more. Okay. Then I guess the next item order is there anyone that has been sworn in that wishes to comment on the application? Okay, anyone else that hasn't been sworn in wish to comment on the application? I do have a question. Have you submitted any application or anything to your homeowners association?
No, because before we can submit our application to the homeowners association, we need a zoning permit.
Okay,
And once we have a zoning permit, then we're going to go to Delaware County to get a building permit. And we need both of those documents before we
Give
can
it
go
to
to
your
our
HOA?
homeowners
Okay.
association.
I've actually heard it, well, and it depends on the development, but we get applications in, of course, Medallion fairly regularly, and Highland Lakes, because they're both so large. It's a little bit of the chicken and the egg. Yeah, I went there first. No, I haven't been there yet. And it's more of just a item of information than anything. It's not a determining factor
Right.
whatsoever. It's just an item of information, that's all.
We have confirmed with Medallion Estates that until we have both a zoning permit and a building permit, they will not accept our application.
Oh, interesting, okay. I wonder
They,
if
they-
that's-
they don't want to see anything that hasn't
I
been
wonder if
already vetted.
that's recently
Yeah.
changed, because we had an applicant maybe 6, 7 months ago that, that had already been to the HOA and they turned it down, and they still came.
Oh.
So.
Okay.
It could be
That causes a little bit of discussion, yeah.
because they might be getting a lot and they want to make sure people are jumping through the other hoops before they get to the final hoop.
Possibly, and every HOA is
Yeah.
different. If you've had a recent change in, members of the HOA, they may have made a new
That'll do it.
policy. There's a whole myriad of things, and like I said, it's just an item of discussion.
Okay.
It's not a reason to approve or deny an
Mm-hmm.
application. It's just an item of information. That's the only reason I ask.
Yes.
So,
We aren't dependent upon their decision,
absolutely not.
and they're not dependent upon ours.
Absolutely not. So just
Independent
because we
bodies.
approve it and we like it in Delaware County and everybody likes it, doesn't mean they're gonna like it.
Understood. Correct, right. But we have communicated with them and we understand very clearly, we can't go to them until we have a zoning permit and a building permit.
Yeah, that's absolutely
Question
fine.
for you, have you done any research to find out whether a 25 or 26% encroachment is something that's been approved in the past by them?
No, we have not.
Yeah.
Well,
It's-
they-
Difficult to contact the HOA directly.
Yeah,
Are you contacting, just as a point of information again, the management, I assume there's a management agency?
Company, yeah, we're dealing with a management company.
Oh,
That is
okay.
exactly right.
I got you.
Yes.
All right. I have a little familiarity with that, even though I happen to live in a development that we don't have an HOA. So one of the few that does, not. So,
Well, your plans go to the Architectural Review Board, I think, right? Don't they have a?
They have an architectural review board that's part of the process. They have their own application that we need to fill out. We need to attach the documentation. We need to attach the plans. We need to show
Building
them
permits.
pictures of, what we're using for windows and doors and the colors and the brick, the brick that we are gonna use, et cetera, so.
mine is like that too. Mine is the same way. We have a design guide and every variance from the design guide, has to be justified.
Yep.
It- It's,
Correct.
it,
Right.
it could be, because they might be getting a lot, and they want to make sure people are jumping through the other hoops before they get to the final hoop.
Yep.
anything else from anybody?
For you, Mark, is 26% in your experience a significant?
25% is usually considered max to be not substantial.
Yeah,
So 26 would be slightly substantial.
substantial.
So,
Have you approved others in Medallion with this type of?
We have, I can't speak to Medallion per se, but I know we have in the past, we've gone far beyond 26%.
Okay, yeah.
Makes the difference, the variance to our back neighbors, they are not in Medallion. They have private property.
So they're outside of the association?
Yes.
Ah,
Exactly.
interesting,
The neighbors to the back of us are not part of Medallion.
interesting.
Okay, is that just
It-
a
it-
small subdivision?
No, it is a single lot. It's
Oh.
it's about a 2.6, 2.7 acre lot
Okay,
that, from our understanding, when Medallion was being created, the person that owned that property would not sell to Medallion, would not negotiate with Medallion, and Medallion finally decided to
built
just
around
go
it.
around them.
Exactly.
yeah,
Uh,
okay.
And
I
so
think I know which property that is now.
it's behind the old farmhouse,
Yeah,
and it sat vacant up until about 2 to 2.5 years ago.
okay.
And then the Auroras bought the property, and as you can see in the picture that's up there, they have completed their home now.
Yeah, that was yeah. That was a situation for a long time there. Okay. Anything else, Mark? Anything? No? Marks?
Not Mark's, yeah.
See, you don't have to be named Mark to be on this board, it just
But it helps.
We're all lined up here, so.
Yeah,
Yeah,
right.
we line
The
up.
others have
just
to start with a
confuse you,
T.
yes. Okay, you guys have anything down here? Anybody want to go through the Duncan versus Middlefield? And you guys,
I did have one
Go.
question for, I just wanted to confirm that it is the 22 feet
Yes, that was,
line. Yeah, I mean, none of the
That's what was
stuff that we
requested.
were given
Yes.
shows it as 22 feet. I just wanted to, I mean, I assume you were probably given other documents that,
yeah,
So
yeah,
that
the
was-
application stated they wanted to be 22 feet.
Okay,
So it's
so-
an 8-foot encroachment into the 30 feet.
okay, cool.
yeah, I think that must be.
Yeah,
what
like I said,
was out of
this sheet, it's not,
The written text, and we probably don't have.
right, so I just wanted to make sure that everyone was, that was consistent with the original application for the permit.
Yeah, 8-foot encroachment into the 30 feet.
Yeah.
So, okay.
I'll do Duncan.
Okay, Mark.
Since I think I squashed the last time, I'll give this one a crack, since it seems like it's going in a decent direction. The property in question relative to this particular application would yield a reasonable return, and it can be beneficial without a variance. Even though that's the case, it's not optimal for you, so we understand the rationale for the application. The variance is somewhat substantial, based on the guidance I received from the chairman. We tend to look at a 25% being the cutoff, and, 8 feet of 30 is like 26, so.
And let me just say this, and let me just interrupt Mark, my fellow Mark, is that whether or not it fails on the Duncan versus Middlefield criteria doesn't, it's just information. It doesn't necessarily mean, well, you made 4, you didn't make the other 5, so it's denied. That's not at all. And you guys did a really nice job on Duncan versus Middlefield. So, which gives a lot of guidance in the decision-making process, which is really what it is. So that's really what it's there to demonstrate.
It's guidance, it's not a checklist.
We have had applications, and by the way, there's a couple questions here that are a pretty standard answer for us, even though it's different for you. For example, the first criteria, can the property be, reasonable return? Well, from our perspective, absolutely it can, if you don't build it. But that doesn't factor in the utility question either. It's that, well, the homeowner has additional utility, whether or not, it adds value or not, it really doesn't have, it is really not necessarily the point. So don't think that it's any more than that, okay?
Shall I?
Yeah, continue.
Yeah. So we just said it's somewhat substantial. The essential character of the neighborhood would not be substantially altered, and the adjoining properties would not suffer a detriment as a result.
Your HOA may not agree with that, but that from our perspective.
Well, in the judgment of this person, and based on the letters that you've received, I feel pretty confident that that's kind of where we're at. The variance would not adversely affect the delivery of government services based on the feedback we got from fire, et cetera. Now, the question is, the property owner did or did not purchase the property with knowledge of the zoning restriction. Our general rule is that everyone that buys a property is expected to know what they're buying into, whether you weren't aware of it or not. So we're going to say that you were aware because you essentially, bought the property, with those restrictions. Is that how we say it?
Yeah, and because, just to add to that, the zoning code is public record, it's public knowledge, and it's just like any other law or statute. You're impugned with the knowledge that it's there, whether or not you have constructive knowledge, not necessarily actual knowledge of the restriction. That's all that means.
It's like tacit knowledge because you did the transaction, right? But it doesn't have a significant impact, and none of these individual things have a substantial impact on your application. It's more something that we need to work through to ensure that we're doing our diligence. The property owner's predicament cannot be feasibly obviated through any method other than a variance. No, it cannot, and we say that because the size and the roof angle that you've planned is the best one for you. So you do not believe, and we do not believe, that your predicament could be obviated through another method other than a variance.
While he goes there, and we touched on this earlier, okay, Joe Schaefer, can we go up to the picture of the back of the house real quick? Because I want to ask a question right looking. Yep. No, keep after the photograph, sorry.
The photograph.
Yep. Can you turn it? Thank you.
There you go.
So this is the kitchen here, I assume?
Correct.
Yes.
Correct.
And then this room is?
Laundry room.
Laundry room. So you don't want it off the laundry room? Okay, I know. And seriously, I asked that in all
I
seriousness.
totally get it.
because That, we gotta ask to see if you can obviate your situation by going off there. But clearly, it doesn't make sense from a utility standpoint to go off the laundry room. That's the reason I ask it. If it was part of the kitchen, I might think, well, maybe. So that's the only reason I ask.
I kind of assumed that was the case based on the plans, so that makes sense to me too. So this approach is the only way that you can address your requirements, and that would be to require a variance. The spirit and intent behind the zoning requirement would be observed, and substantial justice would be done by granting the variance in the opinion of this person. And that's Middlefield.
Okay. Okay, let's see. Okay. Anybody want to make a motion?
All right, I can move.
It's you makes a motion to.
Move to incorporate exhibits A through D. D? We left off at D still.
Sorry.
A through D, as well as the board's findings pertaining to the review of section 307.06 of the Genoa Township zoning resolution into evidence and to approve the requested variance from section 909.01.b of the Genoa Township zoning resolution and the Medallion Estates final development plan for BZA 2025-10, application received September 24th, 2025, to and allow for an addition to a principal building to encroach 8 feet into a 30-foot rear setback on property known as Lot 2027 in Medallion Estates, 5760 Mist Flower Lane, Western Ohio 43082, zoned planned residential zoning district. This motion is based on the following findings of fact pursuant to section 307.04 of the Genoa Township zoning resolution, that such variance or modification will not be contrary to the public interest because it does not adversely affect the neighbors or delivery of government services. That, is that good? Anything? Okay. That owing to special conditions, a literal enforcement of the zoning resolution will result in an unnecessary hardship because they will not be able to use the rear of their home for year-round, placing it within the 30-foot setback is unfeasible, and just generally making it 8 feet smaller as a design would also make it.
22-foot.
Yeah, I was looking at this, and it's 24 feet, so, you know, you
24
drop 8 feet off, you're looking at 16-foot room, which, again, is, would not be enjoyable. That the approval of such variance or modification thereof is consistent with the spirit of the zoning resolution, and substantial justice shall be done thereby, because, again, this won't impact neighbors or services and allows them to greater utility of their backyard and their home.
Okay.
Approve, is there anything else before I keep rolling on?
No, keep going.
Okay.
You're making the motion.
Approval, well, I didn't know if there were any other facts that you wanted me to throw in
No.
that you thought of. Approval of the subject variance is subject to the owner's agreement to the following conditions. All permits, all required permits, zoning or otherwise be obtained pursuant to section 307.11 of the Genoa Township zoning resolution. The approved variance shall lapse, expire, and be null and void ab initio if required zoning permits are not obtained within 1 year of this motion of approval. Extensions to this variance may be requested pursuant to sections 301.11.a and b of the Genoa Township zoning resolution as may be amended. The Board of Zoning Appeals does grant the Genoa Township zoning inspector authority to extend this variance at their discretion, subject to the deadlines established within section 307.11.a of the Genoa Township zoning resolution as may be amended. And I don't believe we discussed any additional conditions.
I don't think so.
All right.
It's your motion.
Yeah, so I mean, I have no other conditions. I just want to make sure.
Second the
anyone else-
motion.
Okay.
Mr. Phillips, seconds. Okay. Discussion? God, you guys. Okay. Okay,
Mark, I guess
go ahead.
I'm very persuaded by the fact that all 4 of your neighbors submitted letters
Yes.
to us through you, approving and agreeing to your encroachment here. It's rare that we see all the neighbors come together and agree to.
Unless it's against.
Yes, yeah.
Also nice not to have someone here, you know, arguing against it,
Right.
which
yes,
we see sometimes.
Yes.
Yep. So, yeah, that was very persuasive to me. So thank you for doing that.
Thank you. Thank you for
Yeah,
sharing that.
You guys, like I said, on the Duncan versus Middlefield, you went through that very well. And you had your ducks in a row, as we used to say in another life. Okay. Are we ready to call a vote? Sounds like we are. Mr. Campanella,
Aye.
Mr. Phillips. Yes. Mr. Wilcoxen.
Yes.
Ms. Hugh.
Yes.
Chair votes yes. Motion carries, and your variance is approved.
Very much.
Congratulations.
We appreciate your consideration. Thank you.
Fun just starts now. You gotta go to your HOA and you gotta start your
Oh.
construction.
The next two.
We got it, we know the next hurdles.
Yeah, exactly. Okay, well, thank you very much.
Thank
And we will conclude this hearing at 7:30. And I think,
Official notification that this has been, okay.
yeah, there's your
guy to
notification
talk
right
to,
there.
yeah,
There's your
yeah.
guy.
He will, yep.
Um,
So is that it?
I guess,
schedule last time, right?
did we, yeah, we approved the schedule last time, did we not?
Yes, that's correct.
Okay, and then, is there any
The-
other?
We have already received an application for the next hearing,
Okay,
so there will be
which
a meeting
is
for that day.
November
It's the 18th.
I was just gonna say
Because of
18th.
the holiday.
Here,
Oh, no.
I'll be gone.
And yeah, you're right, it is the 18th.
Okay.
Hold you in doing the
So,
Putnam versus Minifield.
it's not like
I was-
I,
I
it's
was
not like
cheating
I have a
from the last
life,
time.
so,
Trust me.
okay. So I'll look forward to seeing you guys on the 18th.
I'll be here on the
And,
18th, no problem.
I will not.
Except for Teresa, who will be doing my dream vacation out at the Formula One race. And I guess I'll entertain a motion to adjourn.
So moved.
Second? Okay, all in favor?
Aye.
Any opposed? Okay, hearing none, we are adjourned at
Meeting.
7:32.
Speed meeting.
Yeah.